Welcome everybody. Great to see you tonight in between snowstorms. As you know, at around 3 o'clock today, there was a terrific ruling in Florida regarding the health care law, the individual mandate, holding that unconstitutional and also stating that that portion of the health care law can't be severed from the entire health care bill. So the entire health care law is unconstitutional. Really very, very interesting ruling. It's a 78-page, it was a 78-page decision. I actually read the whole thing between 3 o'clock and coming to this meeting, so I could speak to you a little bit about it. And it now leaves the decisions of the various federal district courts, which have looked at this 2-2. There's a court in Michigan which said that the provision is constitutional. There's also the Western District of Virginia said that the individual mandate is constitutional. The Eastern District of Virginia stated that it is unconstitutional, and now this Florida court has also stated that it's unconstitutional. The next stage will be for the various district court cases to be appealed to the appellate court, the courts of appeal, and then it'll probably, with this kind of division among the courts, it'll probably make its way up to the Supreme Court. I believe that this is the first decision that also held that the entire law was unconstitutional because you can't sever this one provision, the individual mandate. And I just wrote up a couple of details about the decision that are particularly interesting. There was also a challenge to the law based on another provision, which is the Medicaid mandate, which requires states to cover a much larger group of people under the Medicaid law, under paying the penalty of removing federal funding and federal reimbursements for part of the Medicaid monies that states expend. And states challenged this. This is the biggest case. This is the case that was brought by, in Florida, was brought by 26 attorneys general from 26 different states. 22 of them were Republican attorney generals, and 4 were actually Democrats. The court held that the Medicaid, and the challenge to the Medicaid expansion was that it violated the spending clause of the Constitution. And the court held against the plaintiffs here. They said it did not violate, that this Medicaid expansion law, portion of the law did not violate the spending clause. So it was not, the law was not held unconstitutional on that grounds. And then the court turned to the whole issue of the individual mandate. Now, as you may know, the individual mandate required people in Section 1501 of the Health Care Act, and it requires people to buy health insurance, government-approved health insurance, under pain of having to pay several hundred dollar penalty. And that provision of the law kicks in 2014. The court first looked at whether people had standing to bring those claims, and the plaintiffs in this were not only the attorneys general. There were also some individuals who said, I don't want to buy this, it's going to interfere with my business. And even now, even though this provision of the law doesn't go into effect until 2014, I have to start preparing for it. I have to start seeing if I need to lay off employees right now because I won't be able to afford the law. I have to start planning right now. And the court said that that is enough. The fact that you have to start planning for this law now is enough of a harm to the individuals to give them standing to bring the case. Then the court also examined whether the states have standing to challenge the individual mandate. The court looked at the fact that Utah and Idaho had both passed laws saying that people have the freedom to buy whatever health insurance that they want. These laws were passed prior to the Federal Health Care Act being passed. It was in anticipation, obviously, of the law being passed. And the court said that the states have a right to defend the laws that they have put on their books, which conflict with the federal law, so they have standing also to challenge the health care law. Then the court went on to look at the whole history of the Commerce Clause. It's a fairly lengthy decision, and it talked about, discussed the Federalist Papers, how the Commerce Clause originally only was supposed to apply to trade, commerce between states. The idea of the Commerce Clause was to prevent states from enacting trade barriers to goods coming in from other states, so that we should be able to have free exchange among the 13 colonies. That was really the purpose of it. Through the 19th century, it did not, the concept and the idea of what the Commerce Clause meant did not change very much. In the 20th century, at the New Deal, there started to be an expansion of what the Commerce Clause meant. However, and the court traced the whole history of the expansions. At times the Supreme Court has expanded the meaning, at times they've contracted the meaning somewhat, but at the end of, at the end of the day, and end of this long analysis of what the Commerce Clause means, the court has meant throughout, the 200-year history of our country, the court concluded that it never has referred to inactivity. It's always discussed, what is an activity? What types of activities can Congress regulate under the Commerce Clause? In this case, this is really novel. This is the first time that Congress has actually tried to regulate inactivity, a passive decision to not buy insurance. And so this is something that's very novel. And the court pointed to the fact that the Congressional Budget Office and the Congressional Research Office both had looked at this issue prior to the enactment of the Act of the health care law, and they had said it's very novel, it may be subject to challenge, that it was known at the time that the law was passed that there may be a problem with it, and yet Congress went ahead and enacted it anyway, knowing full well that this was a very novel way to try to impose a regulation on the country. And the court rejected the argument that the government made that a decision is activity. A decision is a decision. It's not activity. And it was good, very, very good decision in that respect. And, I can read you some of the language if you'd like from the decision, but that's basically in a nutshell what they said about it. And then the court turned to the whole issue of severability. Can you take this one aspect of the law, can you just carve it out, sever it from the health care law and say, okay, we're going to throw out the individual mandate, we're severing that out of the health care law, but everything else stands, or do we have to throw out the whole law? And generally, what you do, there's a general presumption that you want to try to preserve legislation. Generally, if you can sever a portion of a law, you do that. But the court said, but that really depends on the nature of the law. There are different kinds of legislation that are passed. Sometimes you have legislation which is just really a series of different laws that are all, excuse me. Sorry. We're waiting for the hamburgers to be served. Enjoy. Bon appetit. Sometimes you have a series of laws, a law that's really just a series of little enactments. An example would be, a tax law which says, so we're going to tax hamburgers, we're going to tax cheesecake, we're going to tax ice cream. If you say it's unconstitutional to tax hamburgers, the other two provisions of that law can still stand. But then you have other laws that are sort of like a watch, a finely tuned watch that has a lot of moving parts, and if you take one of those moving parts out, the whole watch isn't going to work well. And the court talked about how the defendants and how the government actually acknowledged how essential this individual mandate is to the whole health care scheme. And Congress had in fact admitted that without the individual mandate, the whole health insurance scheme won't work, because then you can't really convince insurance companies to cover people for pre-existing conditions unless everybody is required to get insurance. The scheme really fails. And the court said, of course there are some provisions of the health care law that could stand independently of the health care mandate. For instance, There's a provision in the healthcare law that employers have to provide separate rooms for nursing mothers and long enough breaks to express milk. You know, that provision, of course, can stand, you know, even if the individual mandate falls. But the court said, we're not going to spend, you know, weeks and weeks and months going through a 2,700-page law to determine which of the provisions can stand and fall when the essential aspects of the law, the essential aspect of trying to have a health insurance scheme that covers everybody will fall as a result of the individual mandate falling. And this is just this is basically, you know, there are 450 sections to the healthcare law. It's like one of these finely tuned clocks, and if you take out the individual mandate, the whole thing falls. So we're going to say that the whole law is unconstitutional. Then the court turned to the issue of an injunction. Oh, we have a question.
Can I ask a question?
Sure.